Hi everyone, it's Jim Filippi coming to you from the Filippi Law Firm. Today I want to talk to you about your trust if you decide to move out of state. So you've possibly made the decision of moving out of state, or maybe exploring the opportunities that are outside of the state of California, but you have your estate plan that you established here in California and you're curious how that affects your trust. Now, trusts are very flexible, and the law here in California and in most other states allow for your trust to be transferred into that state and be administered however that it was originally established, as long as it's not in conflict with the state law. What I encourage people to do if they are thinking of going to another state with their California trust is to meet with a trust attorney in that state to determine if there's any changes to their trust that need to be made so that it is in conformity with that new state's laws. You're also going to want to have a trust amendment done to ensure that your trust is going to be governed by the laws of your new state rather than the laws of California. That's not necessarily 100% required, or it may be required in your state, just depends, and that's why you should sit with an attorney in that state. But here in California, we look at documents that are created out of state and judge them based on the laws of the state in which they were created. So for example, say you created a will in New York and you moved here to California and unfortunately you've passed on. And if you have, you're probably not watching this video, but this is for the planning purposes of this. So your will is created in New York, you've died here in the state of California. The question is my will valid here in California? And the question is possibly, because what California courts will do is look through a certain process. One, they'll first look to see if your will was created in conformity to New York laws when it was created when you were in New York. And as long as that's done properly, then your will would be admitted here in California. Now, let's say that something happened in New York when that will was created and you didn't follow the rules that are in New York. And now we look to the second tier of this evaluation on whether or not your will be admitted to California courts. And so the courts will look to see if what you did in New York when you created that New York will was in conformity with California law. Now that might be a little odd and strange, that why would that have occurred, but you never know. It just depends on what the issues are in New York that may have been a little bit different here in California. Again, each state has different rules, different laws, and so you may have made a mistake in New York but been proper under California law. And that's when that'll happen. So in a basic summary of all of this is that your estate plan is recognizable in other states, but realize that you may have a need to make certain modifications to ensure that you're in conformity with the laws of the new state. So you should meet with your California attorney that can help you get in touch with an attorney in your new state so that there's an easy handoff between the two attorneys in ensuring that your estate plan is updated to reflect the needs of your new state. But rest assured, it's done all the time. In fact, it's one of the most asked questions that I've been receiving in the past year or so. So you're not alone. There is a process in place. You just have to come speak with your estate planning attorney. I hope that helped. I look forward to seeing you at our next video. Have a great day.